Good morning. The Judiciary Committee will come to order, and without objection, the chair is authorized to declare a recess at any time. Pursuant to notice, I now call up H.R. 695 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 695, to amend the National Child Protection Act of 1993 to establish a national criminal history background check system and criminal history review program for certain individuals who, related to their employment, have access to children, the elderly, or individuals with disabilities, and for other purposes.
Without objection, the bill is considered as read and open for amendment at any time. I'll begin by recognizing myself for an opening statement. Nonprofit organizations provide essential youth services to communities throughout the United States. They run camps and after-school programs. They enrich our children's lives by providing them mentorship. That's why it is essential for them to be sure that when they hire someone or enlist a volunteer, that individual is fit to work with children. One of the greatest challenges facing child-serving nonprofits is the ability to properly vet potential employees and volunteers. Access to timely, inexpensive FBI background checks is vital to the success of these organizations. The PROTECT Act of 2003 established a pilot program to provide fingerprint background checks for nonprofits seeking to vet prospective employees. From 2003 to 2011, youth-serving organizations were able to conduct over 105,000 background checks under that program, leading to a discovery that over 6,500 individuals had criminal records of concern. As a result, these nonprofits were able to identify and remove applicants who had committed offenses such as criminal sexual conduct with a child and child endangerment. The success of this program demands permanent implementation. H.R. 695, the Bipartisan Child Protection Improvements Act, introduced by Mr. Schiff and Mr. Bishop, makes the pilot program permanent and expands it to include employees of youth-serving nonprofits. This bill creates a system where youth organizations can streamline both FBI and state background checks when vetting an applicant. It also ensures privacy rights are protected by barring the disclosure of an individual's specific criminal record without explicit consent. Additionally, applicants are provided with the opportunity to correct errors in their records directly with the FBI. Background checks are our first line of defense in protecting our kids. This bill gives youth-serving organizations an additional tool to keep our children safe, and I urge my colleagues to support H.R. 695. Now my pleasure to recognize the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Mr. Chairman, for your description of this measure, which I agree with. We have a special responsibility to protect our young people and vulnerable adults. For that reason, I'm pleased to be an original co-sponsor of H.R. 695, a bill that would provide a robust, easily accessible, cost-effective background check system for organizations that work with youth and vulnerable adults. There are reasons that this bipartisan measure should receive all of our support, if possible. First, it will facilitate more comprehensive criminal background checks, which provide a critical layer of protection. These checks help identify individuals who could potentially harm participants in programs for children, young people, and vulnerable adults. Background checks also serve to ensure the integrity and accountability of the organizations that sponsor these programs by reducing potential threats. Results from background checks that search criminal histories nationwide are more reliable than background checks that only search criminal histories in a few states. Secondly, state background checks are no match for the FBI's fingerprint-based system, which is the only nationwide database that allows a search of criminal histories in every single state. Currently, this database can only be accessed through state law enforcement agencies, and many states limit the ability of organizations to access the system, with some states completely forbidding access. As a result, organizations must navigate a labyrinth of state laws or rely on private companies to perform background checks of employees and volunteers. H.R. 695, on the other hand, would provide organizations with the ability to access the FBI's superior system without impacting the autonomy of states or the organizations. States would be able to continue or establish their own background check system, and organizations would not be required to perform FBI background checks of potential applicants or volunteers. Finally, the need for this legislation is clearly justified by the Child Safety Pilot Program, which we implemented over a decade ago. This program documented the effectiveness of nationwide background checks for youth-serving organizations. Based on a comprehensive review of thousands of criminal history records spanning an 8-year period, the program demonstrated that people who might pose a risk to the safety of children nevertheless attempted to work with children. For example, the program had identified applicants who, to avoid detection, used aliases, incorrect dates of birth, or social security numbers that were incorrect. Some of these applicants had serious criminal histories, including homicides, sexual assaults, child endangerment, and rape. More than 1/3 of criminal history hits were from out of state, and more than half of the people with criminal history hits failed to disclose them on their application. H.R. 695 would allow organizations access to the FBI's comprehensive background check system and thereby help ensure the safety of our youth and others. In closing, I note that there is still work to do to address the incompleteness and lack of accuracy of some of our criminal history records. Although this bill permits those who are disqualified for positions under these checks to challenge the results of their check, more must be done to ensure the accuracy of these records so that individuals are not identified in error as having a particular disqualification in their background. And so accordingly, I urge my colleagues to support H.R. 695, and I yield back, Mr. Chairman, any time remaining.
Thank you, Mr. Conyers. Are there any amendments to H.R. 695? What purpose the gentleman from South Carolina seek recognition?
I have an amendment at the desk, Mr. Chairman.
The clerk will report the amendment.
Amendment to H.R. 695 offered by Mr. Gowdy. Page 6, line 8.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. The Child Protection Amendments Act is garnered support across the board. It aims to make permanent safety programs established in the PROTECT Act of 2003. I'm proposing a small technical amendment which clarifies how the system works and more accurately reflects the role of the designated entities in the bill as a channeler between youth-serving organization and the FBI. Moreover, Mr. Chairman, it emphasizes this bill provides a supplemental way to assure background checks on volunteers and staff who work with children or other vulnerable groups are as comprehensive as possible, and state databases may also be checked by a designated entity. I would respectfully ask my colleagues to support this amendment, and with that, I would yield back to the chair.
Chair, thanks, gentlemen. For what purpose the gentleman from Michigan seek recognition?
Merely to support Mr. Gowdy's amendment, and I thank you.
Chair, thanks the gentleman. The question occurs on the amendment offered by the gentleman from South Carolina. All those in favor respond by saying aye.
Aye.
Those opposed, no. The ayes have it, and the amendment is agreed to. Are there any other amendments to H.R. 695? Given the lack of a reporting quorum, further proceedings on H.R. 695 will be postponed.
Chairman.
For the purpose of the gentleman from Wisconsin seek recognition.
Since we're done with amendments, I ask unanimous consent that the previous question on this bill be ordered.
Is there any objection to order the previous question? Being none, previous question is ordered. Sorry? A reporting quorum being present. Okay, given the lack of reporting quorum, further proceedings on H.R. 695 will be postponed. Pursuant to notice, I now call H.R. 883 for purposes of markup and move the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 883, to amend Title 18 United States Code to provide a certification process for the issuance of non-disclosure requirements accompanying certain administrative subpoenas to provide for judicial review of such non-disclosure requirements and for other purposes.
Without objection, the bill is considered as read and open for amendment at any time, and I'll begin by recognizing myself for an opening statement. Over the past few decades, the Internet has revolutionized every aspect of modern society, including the ways we communicate, socialize, and conduct our business and geopolitical affairs. Unfortunately, it has also been used as a channel for predators to reach our children, a way for predators to reach those most vulnerable of our citizens while they are home, a place where they're supposed to be and feel safe from harm. When a predator succeeds in that mission, the damage is tremendous. That's why the prevention and interdiction of child exploitation crimes committed on the Internet is so important. In 1998, Congress authorized the FBI to use administrative subpoenas in investigations of child exploitation because time is of the essence in these cases. The purpose of these subpoenas is to allow law enforcement to obtain information quickly and efficiently. At times, the ability to do this can be the difference between life and death for an innocent child. In giving this authority to the Department of Justice and the Federal Bureau of Investigation, Congress created a provision whereby the agency could use this subpoena power to gather non-content information from service providers. This capability is narrowly limited to cases of child exploitation. In recent years, service providers have adopted policies where they disclose the existence of these subpoenas to their customers. In these cases, the target of the investigation, in some cases, this can put a victim in imminent danger, cause the target to flee or destroy evidence, or otherwise endanger the integrity of the investigation. This means that law enforcement officers who are using these subpoenas in child sexual exploitation cases where there is significant risk of harm must now apply to courts for non-disclosure orders, which defeats the original purpose of permitting the use of the administrative subpoena to investigate these horrific crimes in the first place. This bill provides a much-needed solution in allowing the official issuing the subpoena to direct the recipient not to disclose its existence for 180 days. It can be used only in cases where the official certifies it is necessary due to the risk of harm, flight, expiration of evidence, or otherwise seriously jeopardizes the investigation. Additionally, and significantly, the bill provides for due process by allowing the recipient service provider to challenge the non-disclosure before court if the recipient chooses to do so. This is an important bill, which makes a narrow but much-needed change to existing federal law and provides law enforcement with a necessary tool to combat child predators when time is of the essence. And I urge my colleagues to support H.R. 883. It's now my pleasure to recognize the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte, and I guess our agreement comes to a screeching halt on the second measure brought before the committee today. I regret that. Members of the committee, child sexual exploitation and abuses are, of course, reprehensible crimes committed against the most vulnerable members of our society. In recent years, these offenses have been increasingly facilitated by use of the Internet. H.R. 883, the Targeting Child Predators Act, would change the administrative subpoena statute to facilitate the prosecution of criminals who commit these terrible crimes against children. Without question, I support the goal of pursuing these criminals. Nevertheless, I'm concerned that the bill would eliminate judicial oversight of non-disclosure orders currently required prior to the issuance of administrative subpoenas. I'm concerned that the bill would eliminate judicial oversight of non-disclosure orders currently required prior to the issuance of administrative subpoenas. Section 3486 of Title 18 of our United States Code authorizes investigators to request a 90-day order of non-disclosure from a district court judge. The order of non-disclosure forbids the recipient, such as an internet service provider, from alerting the target of the investigation of the law enforcement's inquiry. H.R. 883 would extend the non-disclosure period from 90 days to 180 days to allow investigators more time to complete their investigations before the target is informed of the inquiry. Although I would like to have more information about why it is necessary to extend this time information, it's particularly problematic combined with the other significant change to the law made by this bill. H.R. 883 would allow investigators to require non-disclosure of internet service providers without the approval of a judge, thereby eliminating any judicial oversight prior to the issuance of the subpoena. The administrative subpoena authority is an extraordinary power given to certain agencies by Congress under limited circumstances. While the legislation would allow a recipient to challenge a non-disclosure order in court, I am concerned about the bill's elimination of judicial approval on the front end. I understand the desire to do more to facilitate the investigation of these crimes, and that the online context for them has raised issues that we should continue to examine, but I do not believe the committee has enough information justifying this bill, at least in its current form. Elimination of prior judicial approval of non-disclosure orders is a step we should undertake only based on evidence and careful deliberation. A bill such as this warrants at least a legislative hearing to consider its potential ramifications. And in the evidence of this kind of evidence or a meaningful deliberative process, I must accordingly urge the members of this committee to oppose H.R. 883 as I am going to do. I thank the chairman and yield back any time.
Chair thanks the gentleman and is pleased to recognize the chief sponsor of the bill, the gentleman from Florida, Mr. DeSantis, for his opening statement.
Well, thank you, Mr. Chairman, and thanks for the opportunity to be here today to discuss a very important issue facing one of our most vulnerable populations, and to discuss the Targeting Child Predators Act and how it's a simple reform that will help bring predators to justice. Last year, my office was contacted by local law enforcement in Florida who identified a major roadblock they were facing in their quest to bring child predators to justice. One of the local sheriff's office had a major investigation targeting a male who was suspected of sexually molesting his child, yet they knew that issuing an administrative subpoena for his IP address with his name through the internet service provider would end up notifying the predator, the suspect, that this was happening. Of course, once notified of a law enforcement inquiry, suspected predators often destroy vital evidence or flee from prosecution, further endangering threatened children. Now, in this case, the Brevard County Sheriff's Office was thankfully able to locate the perpetrator through other means, and they were able to rescue 13 children, but that was really just a positive twist of fate that led them down that road. This investigation could have come to a conclusion in a timelier manner, though, if they had been able to subpoena the ISP without fear of the suspect being tipped off. Now, the FBI has acknowledged that this is an issue affecting law enforcement jurisdictions across the country. This bill has been written in conjunction with the FBI and the Department of Justice to provide a narrowly tailored solution. The bill will amend federal law requiring that internet service providers in the very specific case of child exploitation wait 180 days prior to disclosing to a specific user that their information was lawfully requested by law enforcement. This bill will prevent suspects from destroying evidence and covering their tracks, giving law enforcement the tools they need to better investigate these heinous crimes without expanding government's authority to subpoena in any way. As a former prosecutor, I know firsthand just how valuable electronic evidence can be to target predators and to protect our children. This act is a simple change to federal law that will help law enforcement across the nation rescue children in abusive situations, preserve critical evidence, and assist in prosecuting these child predators. I yield back the balance of my time.
Chair, thanks, gentlemen. Are there any amendments to H.R. 883? No. Okay. For purpose of the gentleman from Wisconsin seek recognition.
There are no amendments. I ask unanimous consent that the previous question be ordered on the bill.
The question occurs on ordering the previous question. Is there objection? Given the previous question is ordered, given the lack of a reporting quorum, further proceedings on H.R. 695 will be postponed. Pursuant to notice, I now call up H.R. 1188 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 1188, to reauthorize certain programs established by the Adam Walsh Child Protection and Safety Act of 2006 and for other purposes.
Without objection, the bill is considered as read and open for amendment at any time. I'll begin by recognizing myself for an opening statement. It has been over a decade since President George W. Bush signed into law the Adam Walsh Child Protection and Safety Act. The Walsh Act was a monumental bill changing how this nation addresses registering, monitoring, and apprehending sex offenders. Research shows that sexual crimes reported to police declined by an average of 13% within a jurisdiction after enacting a registry. What cannot be quantified, however, is the prevented harm or damage to our children that has been averted thanks to the presence of a sex offender registry. Prevention is key, and that is precisely the goal of the Adam Walsh Act. We must never take that for granted. That's why today we will consider the Adam Walsh Reauthorization Act of 2017, introduced by Congressman Sensenbrenner, the author of the original Walsh Act. This bill reauthorizes the Sex Offender Management Assistance Program and provides funding for the United States Marshals Service, which is tasked with identifying and apprehending unregistered sex offenders. Additionally, the bill expands the time in which a victim of child exploitation or trafficking may pursue a civil remedy. The bill also aims to improve the Sex Offender Registration and Notification Act, or SORNA, and make it easier for states to comply. Thus far, 17 states, 108 tribes, and 3 territories are in substantial compliance with the law. The intent of this bill is to ensure many more jurisdictions come into compliance. Over the past several years, the Department of Justice has worked closely with states to achieve this goal by promulgating flexible guidelines and via the continued hard work of the Office of Sex Offender Sentencing, Monitoring, Apprehending, Registering, and Trafficking, or the SMART Office. The bill takes several concrete steps to encourage compliance. For example, it addresses concerns many have expressed about juvenile offenders. It is important to keep in mind that only juveniles who have committed the most serious sex offenses, such as first-degree rape, are subject to registration under SORNA. Nevertheless, H.R. 1188 lessens the amount of time a juvenile who keeps a clean record must be on the registry. If these youths keep a clean record for 15 years, they may petition to leave the registry. Additionally, under the DOJ guidelines, states who choose to do so may forego putting certain juveniles on the public registry. Further, the bill alleviates the costs of implementation by explicitly permitting alternative means for in-person check-ins for registrants and lessening the number of required check-ins. This is a reasonable amendment that will help states with significant rural populations achieve compliance. Last year, the Adam Walsh Reauthorization Act passed the Senate by a unanimous bipartisan vote of 89-0. Notably, our bill here today goes further than the Senate bill did by including specific provisions to encourage further implementation of the act. As we heard at last week's hearing, there can be no keener revelation of a society's soul than the way it treats its children. I implore my colleagues to take that to heart and support H.R. 1188 to reauthorize the Adam Walsh Act. I now recognize the ranking member, Mr. Conyers, for his opening statement.
Thank you, Mr. Chairman. I support, but with reservation, H.R. 1188, the Adam Walsh Reauthorization Act. On the positive side, the bill reflects changes the committee accepted when we last considered this in 2012 that improved the requirements for states to register sex offenders under the Sex Offender Registration and Notification Act. That bill was adopted by committee by voice vote and subsequently passed the House by voice vote. As we noted last time, however, that while the legislation made some useful reforms, it failed to address fundamental concerns with the Sex Offender and Registration and Notification Act. We find ourselves in a similar circumstance today. The Adam Walsh Act establishes the Sex Offender Registration and Notification Act as a national system for the registration of sex offenders. States that fail to substantially implement it are subject to a 10% reduction in federal grants under the Ed Byrne Memorial Justice Assistance Program, grant program. Whatever one's belief may be about the wisdom and results of sex offender registries prior to the Sex Offender Registration and Notification Act, many states had already developed sex offender registries on their own and devoted substantial resources to identify most effective methods to manage sex offenders. Unfortunately, the Sex Offender Registration and Notification Act forces states to disregard these efforts in favor of a one-size-fits-all system. One of the principal concerns with the Sex Offender and Registration and Notification Act is that it deprives states flexibility in dealing with juvenile sex offender registrations, even though juvenile offenders have been shown to be more responsive to treatment than adult offenders and rarely reoffend sexually when provided with appropriate treatment. Commendably, H.R. 1188 would allow states discretion in determining whether juvenile sex offender information will be accessible to the public via the internet, and it would reduce the time that certain, but not all, juvenile sex offenders adjudicated as delinquent are required to register from 25 years to 15 years. The bill would also insulate local governments from granting funding penalties as a result of their state's noncompliance and give states greater flexibility in methods by which they fulfill reporting requirements. These changes are welcome steps in the right direction to address existing concerns with the Sex Offender Registration and Notification Act. And that may increase compliance. I thank the gentleman from Wisconsin, Mr. Sensenbrenner, and other co-sponsors of this legislation for their steadfast work on these issues. Nevertheless, there's still work that must be done with respect to the registration of justice offenders and other issues. Accordingly, I look forward to considering amendments that address these concerns and that will further improve the bill. As we noted at the time, however, that while the legislation has made some reforms, it failed to address fundamental concerns with the Sex Offender Registration and Notification Act. And so today, I find myself in a similar circumstance now. The Walsh Act the Walsh Act has not accordingly, I look forward to considering amendments that address these concerns and that will further improve the bill. And Mr. Chairman, I yield back any time that may be remaining. Thank you.
Mr. Chairman.
Chair thanks the gentleman and is now pleased to recognize the chief sponsor of the bill and the chairman of the Immigration Subcommittee, the gentleman from Wisconsin, Mr. Sensenbrenner, for his opening statement.
And Mr. Chairman, the Walsh Child Protection and Safety Act, enacted in 2006, is landmark legislation intended to keep our communities and, more importantly, our children safe from sex offenders and other dangerous predators. This bipartisan bill strengthens sex offender registry requirements and enforcement, extended federal registry requirements to Indian tribes, excuse me, and authorized fundings for several programs intended to address and deter child exploitation. The centerpiece of the Walsh Act is the National Sex Offender Registration and Notification Act, known as SORNA. SORNA's goal is to create a seamless national sex offender registry to assist law enforcement efforts to detect and track offenders. SORNA provides minimum standards for state sex offender registries and created the Drew Schrodine National Sex Offender website, which allows law enforcement officials and the general public to search for sex offenders nationwide from just one website. H.R. 1188, the Walsh Reauthorization Act of 2017, reauthorizes two key programs from the original Walsh Act, grants the states and other jurisdictions to implement the Walsh Act sex offender registry requirements, and funding for the U.S. Marshals to locate and apprehend sex offenders who violate registration requirements. Specifically, the bill authorizes not less than $60 million annually through fiscal year 2021, which is consistent with recent appropriations. These programs are crucial to efforts to complete and enforce the national network of sex offender registries, particularly in light of the already passed deadlines for states to come into compliance with SORNA. Based on feedback from the states, the bill makes targeted changes to the SORNA sex offender registry requirements. The bill changes the period of time after which a juvenile's adjudicated delinquent can petition to be removed from the sex offender registry for a clean record from 25 years to 15 years, provides that juveniles do not need to be included on publicly viewed sex offender registries. In addition, it is sufficient for juveniles to be included on registries that are only viewed by law enforcement entities. I believe these provisions strike an appropriate balance between being tough on juveniles who commit serious sex crimes and understanding that there can be differences between adult and juvenile offenders. The bill also recognizes the unique challenges that tribes face in implementing SORNA. It provides technical assistance to tribes so they can enter information into the federal criminal information databases. Finally, H.R. 1188 amends the statute of limitations to allow individuals who are victims of exploitation or trafficking as juveniles They have 10 years after becoming an adult to file suit for civil remedy. It is my hope that with these common sense changes, more states will come into compliance. The Adam Walsh Act has already been a public safety success. To date, the Justice Department has deemed 128 jurisdictions substantially compliant with SORNA requirements, including 108 tribes and 3 territories. This legislation is critical despite ongoing prevention efforts, and the fight against child exploitation is not yet over. I urge my colleagues to support the bill and yield back the balance of my time.
The chair thanks the gentleman. For purpose, the gentleman from Michigan.
Mr. Chairman, I'd like to enter some letters into the record with your approval. We've 3 letters concerning this bill asking us to address problems with the Sex Offender Registration and Notification Act. 1 letter is signed by 21 individuals and organizations, including Impact Justice, the R Street Institute, the Campaign for Youth Justice, the National Alliance to End Sexual Violence, and the Texas Association Against Sexual Assault. And I ask that these letters be made part of the record at this time.
Without objection, the letters will be made a part of the record.
I thank the gentleman.
Chair thanks, gentlemen. The committee will recess for lunch and will reconvene immediately after the first series of votes, which is expected to conclude around 2 p.m. Members would return promptly from those votes. We can proceed to finish completion of this bill, the 2 bills we have already moved the previous question on, and the Mobile Workforce Act. The committee will stand in recess.
Thank you.
The committee will reconvene. When the committee recessed, we were considering amendments to the Adam Walsh Reauthorization Act of 2017. For what purpose the gentleman from Wisconsin seek recognition?
Mr. Chairman, I have a manager's amendment at the desk.
The clerk will report the amendment.
Amendment to H.R. 1188, offered by Mr. Sensenbrenner of Wisconsin. Page 2,
Mr.
strike
Chairman,
line.
I ask unanimous consent the amendment be considered as read.
Without objection, the amendment is considered as read. The gentleman is recognized for 5 minutes on his amendment.
Mr. Chairman, this manager's amendment makes a number of important changes to the underlying bill, while still maintaining its goal of sufficiently reauthorizing the bill and maintaining important improvements. The amendment changes the amount for reauthorization in Section 3, which funds the U.S. Marshals in their Adam Walsh investigation. The bill amends the reauthorization to not less than $60 million. The amendment also eliminates the requirement that the Department of Justice report the number of juveniles that were convicted of statutory rape who are on the National Sex Offender Registry. Statutory rape is antiquated terminology for sex offenses defined in terms of engaging in sexual acts with children below a certain age, in which proof of a lack of factual consent is not a required element. For example, consider the case in which a 17-year-old is prosecuted and convicted as an adult for raping an 8-year-old child under a provision that simply prohibits engaging sexual acts with persons below the age of 12. Under the Section 7 reporting requirement, this would qualify as a statutory rape and would need to be reported as such. Discovering some number of such cases, even if it were feasible, will not be indicative of an overuse of registration in relation to juvenile sex offenders. The amendment also permits some technical assistance for tribes funded by the Department of Justice Working Capital Fund. Finally, it gives discretion to DOJ to determine the appropriate alternative means of in-person verification. These proposals will refine and strengthen the bill, and I urge my colleagues to support the amendment.
For what purpose does the gentlewoman from Texas seek recognition?
Mr. Chairman, I was going to strike the last word at the appropriate time. I have no comments on the manager's amendment.
Okay, we'll come back to you.
Except to say that I support it and yield back.
Excellent. That's good to hear.
Mr.
The gentleman from Michigan seek recognition.
For the purposes of supporting the gentleman from Wisconsin's technical
Gentleman is
amendments,
recognized.
I merely want to congratulate Mr. Sensenbrenner on going through this with such carefulness that we've improved this part of the bill, and I thank him for it. I yield back.
The question occurs on the amendment, the manager's amendment offered by the gentleman from Wisconsin. All those in favor respond by saying aye. Aye. Those opposed, no. The ayes have it, and the manager's amendment is agreed to.
Chairman.
Are there amendments to the manager's amendment? For what purpose the gentleman from Texas
I'd
seek
like
recognition?
to strike the last word briefly.
Gentlewoman is recognized for 5 minutes.
I thank you very much. Mr. Chairman, I rise to speak on H.R. 1188, the Adam Walsh Reauthorization Act of 2017. It is clearly a step forward for all of the reasons that we will hear as we proceed in the markup of this bill. It is certainly an improvement over current law with a very strong, very important subject, but we hope that it will do more as we go forward. We know the tragic and horrific story of Adam Walsh, but we know it of so many children that have suffered this violent response to their young life, either death or sexual assault, where they have survived. This bill is a step forward in our effort to address concerns about the Sex Offender Registration Notification Act, commonly known as SORNA. We must address some of the issues that have persisted with SORNA since its enactment. There is no doubt that child sexual exploitation is a plague on our country. Mistreatment of children should not be tolerated, and we have a duty to carefully craft the solutions in making sure that it is clear, because the importance of criminal justice law is to make sure that the perpetrator is both found and tried under a clear understanding of which he or she is brought to justice. The creation of a uniform nationwide standard for sex offender registries in the Adam Walsh Act of 2006 was certainly laudable with the emphasis on prevention and protection. Congress soon found, however, that state implementation of SORNA would not occur as quickly as possible or easily. Many states were unable to comply, and some would not comply because of disagreements about who should be subject to mandatory registration. Problems with SORNA were still evident in 2012 when we last considered but did not complete reauthorization of the Adam Walsh Act. Now, 10 years after the enactment, we have the opportunity to address some of these concerns. According to the Department of Justice Office of Justice Programs, only 17 states, 3 territories, 103 Indian tribes have substantially implemented SORNA. States continue to incur penalties. What we want is results. Juvenile registration is still the most significant barrier. Research has shown that the treatment of juvenile sex offenders must be addressed in a community-based approach and intervention and therapy. Researchers have also found that adolescents who completed sexual offender treatment has had a lower recidivism rate. In order to implement the approaches to this treatment of juvenile offenders that have proven successful, states must have flexibility in the manner in which they handle juvenile sex offenders. But we must also get the facts. We must also know the facts. So I believe that we have a task in front of us. I do and want to add my appreciation to Mr. Sensenbrenner for looking carefully and diligently through the bill and his manager's amendment that has already passed. And I look forward to us giving the important instructions that the Attorney General will need, as well as the states will need, and to be able to move forward on the intent, purpose of this bill, but more importantly, to coddle, nurture, protect, and love, and stand for and fight for the juveniles, the victims, and as well to find some opportunity for the bill or the legislation to work effectively throughout the nation. I thank you, and I yield back.
Chair thanks the gentlewoman. For what purpose the gentleman from Utah seek recognition?
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment to H.R. 1188 offered by Mr. Chaffetz. Add at the end of the bill the following.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Mr. Chairman, I thank you for championing the reauthorization of this bill and moving it forward. I also want to thank Chairman Sensenbrenner for his approach and attention to this issue. Since its inception, the Adam Walsh Act inclusion of juvenile offenders has generated much discussion on the contours of this policy. On the one hand, society does not want youthful, simple mistakes to change the course of a juvenile's life forever. On the other hand, society must assure that a juvenile who has demonstrated a propensity to commit serious, dangerous, violent offenses does not endanger others. Recognizing this tension, the Adam Walsh Act merely sets forth that juvenile adjudications of the most egregious kind should be registered, and only for those of the age 14 years old and older. This amendment further clarifies this point by narrowing the definitions for these egregious offenses used in the Act. Some propose adding a discretionary component to this provision. Doing so, however, will not protect victims, and it may have negative consequences for those juveniles. We should embrace a policy that requires those who are most dangerous to register with law enforcement. There must be appropriate supervision for a teenager who commits a violent rape. Only days ago, a 14-year-old girl was brutally raped in a bathroom stall at her school. One of the perpetrators was 17 years old. That's not a youthful indiscretion if the media reports are accurate. That's not innocent exploratory conduct of a confused young person. That's a violent, predatory, horrific offense. If he were charged as a juvenile, wouldn't you agree that he should have this type of monitoring contemplated by the Sex Offender Registration and Notification Act? SORNA, as we know it. Second, a discretionary system gives states carte blanche to jettison any registration of juvenile adjudications, even the extremely narrow registration requirements covered by SORNA. This will have undesirable consequences for some of these juvenile offenders. Where a state has no mechanism to register these juveniles, there will be a greater chance that the juvenile will be charged as an adult where possible. That means he or she will not be on a non-public registry. They will not be able to get off the registry early as this bill provides. And most significantly, they will spend far more time in prison than if adjudicated in a juvenile court. If you're in a jurisdiction where a prosecutor can choose whether to prosecute a juvenile in adult court or a juvenile in a juvenile setting, a prosecutor is tasked with protecting the community may choose to prosecute that juvenile in an adult court if he or she does not feel the community will be protected by the limited consequences of a juvenile adjudication. I'm offering a solution whereby Congress makes clear only the most serious offenses will qualify for a juvenile for registration. The Act states that the juvenile offenders should be registered for offenses comparable to 18 U.S.C. 2241, which criminalizes aggravated sexual abuse. That statute has 3 subsections. Subsection A of the statute punishes sexual acts committed by force or threat of force. Subsection B punishes sexual acts committed after the offender drugs a victim or renders them unconscious. Subsection C bans any sexual act, even those without force, with any person under the age of 12. The Department of Justice guidelines on this matter make clear that states need only to address offenses under subsection A or B, not under subsection C, to be compliant. This will add to the other provisions in Adam Walsh to make sure that we're treating these juveniles fairly and justly. The present bill reduces the clean record provision to 15 years and also allows states to keep juvenile adjudications non-public. Taken together, this is a comprehensive approach in carving out which juveniles should be registered and how they should be treated. The amendment codifies the guidelines to make clear that only the most serious offenders should be included, and that's why I'm sponsoring this amendment, and I hope my colleagues can join me in supporting it. Yield back.
Question occurs on the amendment offered by the gentleman from Utah. All those in favor respond by saying aye.
Aye.
Those opposed, no. The ayes have it, and the amendment is agreed to. Are there further amendments to H.R. 1188?
Chairman,
What purpose the gentlewoman from Texas seek recognition?
I have an amendment at the desk,
The clerk will report the amendment.
which I think falls as 004XML at the end of the bill, section 12.
Amendment to H.R. 1188 offered by Ms. Jackson Lee of Texas. Add at the end of the bill
Without
the following.
objection, the amendment is considered as read, and the gentlewoman is recognized for 5 minutes on her amendment.
Our job here is to stop any harm from being done and to do no harm to the purpose of this legislation, to save lives, to stop violent perpetrators and attacks and sexual attacks against our young victims. At the same time, I think that we must operate on facts, and we must also seek to ensure that we improve the compliance and participation of all states so that we have a deterrent that is strong and credible. One of the most difficult issues we must address with respect to the Sex Offender Registration Notification Act requirements is the registration of juveniles. That is why I'm offering this amendment to require the National Institute of Justice to prepare and submit to Congress a report on the public safety, recidivism, and collateral consequences of long-term registration of juvenile sex offenders. We have heard so much about the negative, unnecessary, and counterproductive consequences to juveniles who are forced to register. Many juvenile offenders are themselves victims who need treatment, and we know that they are amenable to and responsive to treatment. They are, in fact, in many instances, young and susceptible to guidance. They need help so they can heal and so they are less likely to reoffend. In fact, recidivism rates for these juvenile offenders are already very low, and registration does not improve public safety. But what we want to do is to make sure that we have all states complying, all jurisdictions. Studies show that the rate at which juveniles commit new offenses, an already low number, is not further reduced through registration. Juveniles who are registered often face psychological harm, social alienation, life obstacles. In some states, for example, children on the registry are denied a normal education among their peers because much or all of the school environment is off limits to them. Families must relocate if their house is too close to a neighborhood school or park. Some children are removed from their own homes if they have younger siblings, frequently landing them in perilous foster care or juvenile justice settings. So many of us have heard of the unevenness and challenges of foster care and the juvenile justice detention centers that many children may be in. Almost universally, these children grow up isolated and depressed, and it is telling that 1 in 5 children raised on registries attempt suicide at some point in their lives. These are concerns that must be addressed. We need the Justice Department to focus on them. That is why I offer the Jackson Lee Amendment to require the NIJ to study these issues. This study would allow us to better understand the implications and effectiveness of this approach. Are we truly protecting the public? and whether or not we are finding ways to take these young actors, if you will, out of this life and steering them in the direction while rehabilitating them and the child victim. Let me indicate, if I can, 3 points. Violence of youth registrants and their families, 52% are the targets of vigilante violence, including threats to their lives. 85% report serious psychological harm as a result of registration. 1 in 5 attempt suicide. Many succeed. 44% of children on the registry experience homelessness due to safety zone restrictions, and 77% reported that registration not only impacted the registrant, but significantly harmed their families. I ask my colleagues to support the Jackson-Lee Amendment as we move forward for more informed decisions and a better way of serving this population.
Would the gentlewoman yield?
I'd be happy to yield.
I thank the gentleman for yielding. I think she has a fine amendment that I certainly am pleased to support, and I think it complements the work that the committee just did in adopting the amendment by the gentleman from Utah, because it will provide us with more information on this sensitive point regarding juveniles as we move forward. I urge my colleagues to join me in supporting the amendment. The question occurs on the amendment. All those in favor respond by saying aye.
Aye.
Those opposed, no. The ayes have it, and the amendment is agreed to. Are there further amendments to H.R. 1188?
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Amendment to H.R. 1188 offered by Mr. Conyers. Add at the end
Without
of the bill.
objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. My colleagues, I offer this change to the statute defining which convictions and adjudications require notification by allowing states discretion as to whether they will register juveniles adjudicated delinquent for sex offenses. And it's my position that we must give states the opportunity to make sound decisions based on the best research, evidence that may have not been available in 2006. But even then, most advocates and proponents of federal sex offender registration and notification laws never intended for youth adjudicated in juvenile court to be included on these registries. Patty Wetterling has deep concerns about the wide-reaching scope of today's registration laws. She's the mother of Jacob Wetterling, who was abducted in 1989, never found, and became the namesake for the first federal law to mandate that states create sex offender registries. And so I urge the careful and appreciated support of this amendment, and yield back the balance of my time.
What purpose does the gentleman from Utah seek recognition?
I oppose this amendment and move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. As we've been talking about in the discussion here, here's one of the concerns about, and the amendment that I just offered, which was widely supported, which I appreciate, really added to the statute in that we were going to identify violent actions, including the drugging or making somebody unconscious or participating in making that person unconscious, as a bar that would require notification under this act, even if they were a minor. As you go back and look at the amendment that I had offered, it excluded Section C, which is less violent in its approach. My concern is that if you were to go forward with the amendment that Mr. Conyers has offered, you're going to add discretion such that some prosecutors will actually feel as if they need to adjudicate in not the juvenile court, but they will want to ratchet that up in order to protect society and have the notification. And so I think it would actually have the reverse effect of what I think the gentleman from Michigan is trying to actually do. So let's target those that are acting violently, the threat of use of force, the threat of force, rendering somebody unconscious. That seems to me to be an appropriate level to say, all right, you need to be on the registry. But if you're participating in maybe a youthful indiscretion, maybe stepped over the line, there are infinite number of possibilities, that would add more discretion to it. But to blanketly say, hey, if a 17-year-old is involved in a violent rape, and we're not going to put them on that registry and we're going to give that discretion, I don't think that's the spirit of what we're trying to do. So I would urge that we not pass this amendment that's before us at this point, as I think it will have quite the opposite effect of what I think the gentleman is ultimately trying to do. With that, I'll yield back.
Question occurs on the amendment offered by the gentleman from Michigan. All those in favor respond by saying aye.
Aye.
Those opposed, no. Opinion of the chair, the noes have it. The amendment is not agreed to.
Recorded vote is requested.
Recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Smith? Mr. Shabbat? Mr. Issa? Mr. Issa votes no. Mr. King? Mr. Franks? Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Chaffetz votes no. Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Gowdy votes no. Mr. Labrador? Mr. Farenthold? Mr. Collins? Mr. DeSantis? Mr. DeSantis votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Deutsch votes aye. Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Mr. Schneider votes aye.
The gentleman from Arizona.
Mr. Franks votes no.
The gentleman from Texas, Mr. Poe.
Mr. Poe votes no.
Gentleman from Texas, Mr. Gomert. Okay. The gentleman from Texas, Mr. Ratcliffe.
Mr. Ratcliffe votes no.
Has every member voted who wishes to vote? Clerk will report.
Mr. Chairman, 11 members voted aye, 15 members voted no.
And the amendment is not agreed to. Are there further amendments? What does the gentleman from Texas seek recognition?
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Amendment to H.R. 1188 offered by Ms. Jackson Lee of Texas. Add at the end of the bill.
Without objection, the amendment is considered as read, and the gentlewoman is recognized for 5 minutes on her amendment.
Thank you very much, Mr. Chairman. I think it's important to view the amendments of Mr. Conyers and Mr. Javits, Ms. Jackson Lee, as equal in the sense that we recognize that there is a very high calling to this legislation. And I would not in any way want to dampen or undermine the importance of this legislation. I was here when it was first introduced and have been supportive from the very beginning. But I do believe it is important to recognize that children are sometimes involved as offenders. So allow me to read this story. When Matthew Guartalio was 10 years old, he and his older brother initiated a touching game with their 8-year-old sister. None of us knew what we were doing, he said, and he soon forgot about the episode. But later that year, 1998, his sister's teacher found out and notified the authorities. Just weeks after Matthew's 11th birthday, on that incident, police officers handcuffed him outside his 5th grade classroom. This comes under a headline in the New York Times, "Punishment That Doesn't Fit the Crime," which I ask unanimous consent to introduce into the record.
Without objection, it will be made part of the record.
Matthew and his parents agreed to a guilty plea in exchange for 2 years of probation, which he spent in a foster home. His brother also pleaded guilty. When he returned to his family, they were stunned to learn that he was listed on the Texas Sex Offender Registry website and would be for 10 years. He was just 13 years old. Neighbors threw a Molotov cocktail at his house and shot and killed his family's dog. Local newspapers listed him by name along with adult sex offender monsters in the area. He soon hated life and hated everybody else. His parents' marriage was shattered. My amendment provides an inquiry through the judicial system that I believe is both protecting of the underlying legislation, but is also helpful and instructive to the juvenile perpetrator engaged. And so my amendment in particular that I'm offering, because we cannot allow this kind of tragedy which happens to go forward, is to allow a judicial inquiry and to amend the provision that defines which juvenile adjudications of delinquency qualify as offensive, which trigger mandatory registration. It would add a new requirement that an adjudication for an otherwise qualifying offense would trigger the registration requirement only if the judge presiding over the delinquency proceeding finds that registration is necessary to protect the public safety. These are the simple questions that will be asked. The results of a risk assessment of the offender, the age of the offender at the time of the offense, the age of the victim at the time of the offense, the nature of the conduct that constituted the offense, the offender's potential for rehabilitation, the effect of registration on the offender, victim, family members, and community. Now, I think this committee, which has oversight over our laws that impact our judiciary and certainly are well aware of the state system and the federal system, recognize the competency of our judges in most and many instances to be able to make that inquiry. That, I think, would provide a fair approach to dealing with this issue of what happens to the innocence of those who had this situation occur. In the instance of this young man, his life was shattered, unable to find work or attend college because his status was that he was a known sex offender. So I would ask my colleagues to really consider the idea that we could have this layer that would do no harm. And I ask my colleagues to support the Jackson Lee amendment. With that, I yield back.
The chair thanks the gentlewoman and recognizes himself in opposition to the amendment. First, that is a compelling and awful story that you described. However, SORNA does not cover both the age or the behavior that's mentioned in the incident that you have recounted, that you've just read. It would be unwise to delegate registration of violent sexual juvenile offenders to judges. The goal of the Adam Walsh Act is to create a nationwide registry to ensure consistency in the way sex offenses are categorized and offenders are registered. It also ensures jurisdictions are able to share information about these dangerous offenders. Juvenile offenders who commit violent sexual crimes, such as aggravated sexual abuse, which means both forcible rape and rendering someone unconscious in order to commit sexual assault, must be registered. I don't know why anyone would disagree with that. Making this process discretionary will set a lower bar for jurisdictions to meet with respect to juvenile offenders who have committed aggravated sexual abuse, which means the public would be less safe from violent sex offenders. I think the gentleman from Utah has very well reflected the difference between the kind of incident that you described and the kind that we are concerned make sure get registered, and why I'm pleased that in a bipartisan way we adopted his amendment. But I'm also happy to yield to the gentleman for his comments on this.
I thank the chairman. Chairman, I think you're right in that the sad, really sad situation that was laid out by Ms. Jackson Lee would not be, does not fit the qualification, particularly even after the amendment that I offered that was accepted by the committee. We can't give up on these kids in any way, shape, or form. But at the same time, the scenario that was laid out would, as the chairman stated, would not trigger somebody to be on this registration, and that's why I think we should vote no on this amendment.
Mr. Chairman.
Yield back.
For the purpose of the gentleman from New York seek recognition.
Mr. Chairman, I rise in support of the gentlelady's amendment. I want
Gentleman is recognized for 5 minutes.
Thank you, and I want to commend her for offering it. When you're dealing with sex offenses, people get properly horrified, but you have to look at the real-life situation, and you have to allow, as our justice system generally does, for discretion and for judges making decisions. The problem without Ms. Jackson Lee's amendment is that you have no discretion, and that you can have a situation such as she described, and probably a lot of such situations such as she's described. And by the way, my understanding is that the National Registry includes automatically the state registries, and some of the state registries have ages much below 14, and the definitions of violence would not strike most people as in fact violent. So you get tragic situations such as described by Ms. Jackson Lee, and that results in lifetime sex offender status, which can ruin people's lives. So I think you have to allow for some human discretion in these cases, and that's why we have judges. And if the judges aren't proper, get better judges. But you have to allow for some human discretion, or you're going to get a lot of very horrible situations and destroy people's lives for things that were done at 12 or 13 years old, or even 15. It shouldn't destroy someone's life, especially if it isn't so terrible, which under some state laws it isn't, even though they're then covered in the federal registry. So I urge my colleagues to approve the gentlelady's amendment, because there has to be some human judgment and some humanity in our laws. I yield back.
Will the gentleman yield?
Sure.
2 points I'd just like to make. The amendment that we did accept earlier puts that threshold, again, dealing with minors here, for those that use force, a threat of force, drug a victim, or render them unconscious, while leaving off the others that may be certainly less in terms of their intent and severity. But I would also point out that the gentlewoman from Texas offered, and we did accept as to this bill, a reporting requirement from the National Institutes of Justice to prepare and submit to Congress a report on the public safety, the recidivism, the collateral consequences.
Reclaiming my time. I appreciate the gentleman's observation, and it's a good idea to have a reporting requirement, but a reporting requirement is not sufficient to deal with this problem, number one. And when you say we accepted an amendment for that there has to be a force or the threat of force, that can be interpreted, and has been in many cases, as minimal, as some 12-year-old kid punching somebody or threatening to punch somebody, and that shouldn't result in a lifetime bar and a lifetime bar from all kinds of things, from going to college, from whatever. So, again, I don't care how you write it. There's got to be some human discretion, and you've got to trust judges to some extent, and that's why I support the gentlelady's amendment. I'll yield back.
The gentleman will yield one more point. You cited a 12-year-old.
Yielded back, but reclaiming my time, if the chairman will agree, I will be happy to yield.
Go ahead.
I believe the age requirement is 14-year-old. So the two examples that we've had as hypotheticals, none of which fit.
Reclaiming my time, a 14-year-old, everything you said about a 12-year-old, I would say about a 14-year-old.
Gentleman, yield back.
I yield back.
Question occurs on the amendment offered by the gentlewoman from Texas. All those in favor respond by saying aye.
Aye.
Those opposed, no. No. Opinion of the chair, the noes have it. The amendment is not agreed
Roll
to.
call vote, Mr. Chairman.
A roll call vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Smith? Mr. Smith votes no. Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. Issa votes no. Mr. King? Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Chaffetz votes no. Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Gowdy votes no. Mr. Labrador? Mr. Farenthold? Mr. Collins? Mr. DeSantis? Mr. DeSantis votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler? Aye. Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee?
Aye.
Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Aye. Mr. Johnson votes aye. Mr. Deutsch? Aye. Mr. Deutsch votes aye. Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Mr. Schneider votes aye.
Alabama.
Ms. Roby votes no.
Gentleman from Texas, Mr. Poe.
Mr.
Gentleman
Poe
from
votes
Texas,
no.
Mr. Gomert.
Mr. Gomert votes no.
The gentleman from Maryland, Mr. Raskin.
No, come in.
Mr. Raskin votes aye.
Has every member voted who wishes to vote? The clerk will report.
Harris, I want to acknowledge him. Tell him to come in. Sorry.
Mr. Chairman, 11 members voted aye, 17 members voted no.
And the amendment is not agreed to.
Mr. Chairman,
What purpose does the gentleman from Texas seek recognition?
just a moment of personal privilege. He probably will not come back in the room, but since he is my constituent, I wanted to acknowledge Carl Lewis, who has done a lot on the issues of athletics and young people. And so in his absence, he was here listening to the debate. And as you well know, he is a renowned Olympian and still doing great work in Houston now with the University of Houston.
Well, I'm sorry we did not know that while he was here. I hope he does come back. We certainly will acknowledge him, and we thank you for bringing that to our attention, and we thank him for his good work in this area.
Thank you. I yield back.
Question occurs, well, actually, there are no more amendments. A reporting quorum being present, the question is on the motion to report the bill H.R. 1188 as amended favorably to the House. Those in favor will say aye. Aye. Those opposed, no. The ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Let's go back. The committee will return to H.R. 695, the Child Protection Improvement Act of 2017. Before the committee recessed, this bill had been completed and the previous question ordered. The question occurs on passage of H.R. 695. All those in favor respond by saying aye. Aye. Those opposed, no. The ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Prior to the recess of the committee also considered H.R. 883, the Targeting Child Predators Act of 2017, for which the previous question was ordered, and the question now occurs on reporting the bill. A reporting quorum being present, the question is on the motion to report the bill, H.R. 883, favorably to the House. All those in favor respond by saying aye. Aye. Those opposed, no.
No.
Being the chair, the ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views. Pursuant to notice, I now call up H.R. 1393 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 1393, to limit the authority of states to tax certain income of employees for employment duties performed in other states.
Without objection, the bill is considered as read and open for amendment at any time. I'll begin by recognizing myself for an opening statement. The Mobile Workforce State Income Tax Simplification Act provides a clear, uniform framework for when states may tax non-resident employees who travel to the taxing state to perform work. In particular, this bill prevents states from imposing income tax compliance burdens on non-residents who work in a foreign state for 30 days or less in a year. The state tax laws that determine when a non-resident must pay a foreign state's income tax and when employers must withhold this tax are numerous and varied. Some states tax income earned within their borders by non-residents, even if the employee only works in the state for just 1 day. These complicated rules impact everyone who travels for work and many industries. As just one example, the Judiciary Committee heard testimony in 2015 that the patchwork of state laws resulted in a manufacturing company issuing 50 W-2s to a single employee for a single year. The company executive also noted regarding the compliance burden that, quote, many of our affected employees make less than $50,000 per year and have limited resources to seek professional advice. States generally allow a credit for income taxes paid to another state. However, it is not always dollar for dollar when local taxes are factored in. Credits also do not relieve workers of the substantial paperwork burdens. There are substantial burdens on employers as well. The committee heard testimony in 2014 that businesses, including small businesses that operate interstate, are subject to significant regulatory burdens with regard to compliance with non-resident state income tax withholding laws. These burdens distract from productive activity and job creation. Nevertheless, some object that the states will lose revenue if the bill is enacted. However, an analysis from Ernst & Young found that the bill's revenue impact is minimal. There is little motive for fraud and gaming because the amount of money at issue, taxes on 30 days' wages or less, is minimal. Also, the income tax generally has to be paid. The question is merely to whom. Nor does this bill violate federalism principles. On the contrary, it is an exercise of Congress's Commerce Clause authority in precisely the situation for which it was intended. The Supreme Court has explained that the Commerce Clause was informed by structural concerns about the effects of state regulation on the national economy. Under the Articles of Confederation, state taxes and duties hindered and suppressed interstate commerce. The framers intended the Commerce Clause as a cure for these structural ills. This bill fits squarely within this authority by bringing uniformity to cases of de minimis presence by interstate workers in order to reduce compliance costs. Last year's version of the bill passed the House on suspension by voice vote. This year's version is nearly identical with two substantive changes. The professional entertainer exemption is narrowed from a person who performs services to a person of prominence who performs services, in order to ensure that other entertainers retain the benefit of the bill's protections. Second, the list of exclusions is expanded to cover film production employees if associated tax credits for in-state productions are contingent on withholding film production wages earned in the state. This avoids disruption of such arrangements. I commend the bill's lead sponsors, Representatives Bishop and Johnson, and thank all of the bill's co-sponsors. I urge the bill's passage and reserve the balance of my time.
Mr. Chairman.
What purpose? The gentlewoman from Texas seek recognition.
Mr. Chairman, you were so kind to say that if Mr. Lewis returned.
She wants to introduce.
Okay, we are going to suspend our discussion.
Yes, I'm so sorry.
And
You were kind enough to say that if Mr. Carl Lewis and his team returned, since I claim him now as my constituent, that you would allow him to stand and be introduced with his team. And since we're discussing the issues of juveniles in this nation, I want to acknowledge that he is a very vibrant, vocal, vigorous advocate for fitness, but more importantly, working with young people across the nation and still holding Olympic records, of which we applaud him. My friend, my constituent, Carl Lewis.
Mr. Lewis, we thank you for gracing us with your presence and for, more importantly, for your interest in these issues and the work you do with America's youth. Thank you very much.
And can we get your autograph?
Mr. Conyers, you wanted to say something?
The line starts out in the hallway.
Mr. Chairman,
What purpose does the gentleman from Michigan seek recognition?
I rise to strike the requisite number of words.
Gentleman is recognized for 5 minutes.
Thank you very much. The Mobile Workforce State Income Tax Simplification Act. It's a troublesome difficulty here because it attempts to solve a logical and legitimate problem presented by employee tax liability and employer withholding requirements. Many, as you know, employers are subject to multiple tax compliance record-keeping requirements for their mobile workers. These workers are often subject to potentially conflicting and confusing multiple state income tax requirements, and the paperwork for both employers and employees are complicated and time-consuming. Filings, even for minuscule amounts of income, can be burdensome to state revenue departments. Unfortunately, H.R. 1393, if enacted, could result in some states losing millions of dollars in revenue. In fact, New York could lose an amount so large I don't want to destabilize my colleague sitting on the dais with me. Fortunately, this legislation only needs some simple changes to eliminate these negative impacts. For example, the bill currently has a 30-day threshold before an employee would be required to pay income taxes in a state. A much lower threshold would be fairer to the states and still provide certainty to employers and employees alike. In addition, the bill's timekeeping requirements could be tightened to help prevent tax avoidance. A solution appears to potentially close, and accordingly, I look forward to working with my colleagues and the various stakeholders to finally achieve this goal. I'd be remiss if I didn't take this opportunity to urge my colleagues to pass a fair and uniform framework to allow states to collect taxes owed on remote sales rather than proceed with this flawed bill, in my view. By staying silent since the Quill decision by the Supreme Court in 1992, Congress, we have failed to ensure that states have the authority to collect sales and use tax on internet purchases. While this decision may have made sense in 1992, it has not stood up well over time. In 2015 alone, $26 billion owed to states went uncollected. Lost tax revenues mean that state and local governments will have fewer resources to provide their residents essential services such as education and health care. This Congress, House Republicans are advancing both Trump care and a disastrous budget that would both cut untold amounts of federal assistance to the states. In light of these looming funding cuts, the loss of billions of dollars in state revenue is more pressing than ever. And so this committee should move swiftly to close the internet tax loophole by passing legislation this Congress, if possible. I thank the chairman, and I commend my considerations to the entire committee. I yield back.
Chair thanks the gentleman. What purpose the gentleman from New York seek recognition?
Strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. In your opening remarks supporting the bill, you said that this bill would have minimal fiscal impact on the states. I don't know what minimal means, but for New York, it would be well over $100 million. That's not minimal. We reported, I think last year, a bill. I mean, New York, we feel like a punching bag. We reported a bill last year on foreign collections that would have cost, or that would have cost the New York State about, as I recall, $600 million. Now we have an amendment to the Health Care Act that the Republicans are pushing, which would, I mean, the Health Care Act itself would cost New York State about $4.6 billion. The amendment, in the manager's amendment, would deal with another $2.3 billion. So these minimal things add up. And while I do not question the right of Congress under the Interstate Commerce Clause to regulate this as this bill proposes, not every right should be exercised. This bill would harm New York considerably. It might harm other states too. I will offer 2 amendments in the nature that would mitigate the harm, but it's substantially harmful, and there's no good reason, especially in this modern age of electronics and computers, why we should suddenly rein in the states from what they've been doing and what the business community has been tolerating for a very long time. And, the federal government should not get in the way of the states collecting their own revenues, except when absolutely necessary. I yield back.
Mr. Chairman.
What purpose does the gentleman from Georgia seek recognition?
Move to strike the last word.
Recognized for 5 minutes. I recognize the gentleman from Georgia. The gentleman from Rhode Island is the ranking member on the subcommittee. Is the gentleman? We're going to go to the senior gentleman from Georgia on the full committee and recognize him for 5 minutes.
Thank you, Mr. Chairman. I'd like to thank this committee for once again considering H.R. 1393, the Mobile Workforce State Income Tax Simplification Act of 2017. I'm pleased to lead this important bipartisan bill with our Ways and Means colleague, Representative Bishop. H.R. 1393 will help workers and small businesses across the country. States currently have varying standards for employees to file personal income tax when working out of state, and for employers to withhold income tax for workers who travel out of state. H.R. 1393 would provide an easy-to-administer standard that simplifies the patchwork of existing inconsistent and confusing state rules. It does this by establishing a uniform and fair law that ensures the correct amount of tax is withheld and paid to the states without overburdening employees or their employers. Take my home state of Georgia as an example. Acuity Brands is a Georgia-based company with facilities around the country that employs over 4,000 associates nationwide, associates who travel extensively across the country for training, conferences, and other business. Acuity is one of many companies that have expressed their support for H.R. 1393 because the bill limits the substantial operational and administrative burdens on the company by bringing clarity and simplicity to our complex tax system, specifically on the issue of what constitutes work travel and work days for tax purposes. I'd like to ask unanimous consent to enter into the record Acuity Brands' letter in support of the bill, as well as a list of 82 companies with a Georgia presence who or which are in support of this reform effort. Many of these companies have a national brand and provide thousands of jobs, such as Costco, Apple, Lockheed Martin, and Walmart. In addition to working to make sure this is a bipartisan bill, we've also taken steps to ensure the text is cognizant of shifting state tax policies and industry needs. For example, because over 37 states have passed film tax incentive programs so as to encourage the film industry to produce films in less traditional markets, we've added language to the bill that would exclude qualified production employees in the film, television, and video production industry. Atlanta is a growing film and TV hub, and this update allows for states like Georgia and New York with film tax incentives to rely on those revenues for qualified employees. I thank my colleagues for their work on this bill, and in particular, my friend, Congressman Bishop, for his leadership on this bill in this Congress. In closing, I urge my colleagues to support H.R. 1393, and with that, I yield back.
The chair thanks this gentleman for his good work on this legislation, and with apologies to the ranking member of the Subcommittee on Regulatory Reform, now recognize the gentleman from Rhode Island for 5 minutes.
Thank you, Mr. Chairman. H.R. 1393, the Mobile Workforce State Income Tax Simplification Act, would establish a uniform standard for the collection of state income tax for non-resident employees. This bill addresses a widespread problem in the collection of income taxes for these employees who travel outside their state of residence for work. While every employee must file state and federal income tax returns, employees who travel for work may also have to file an income tax return for every state in which they travel. That's because of a patchwork of complex laws that apply to personal income tax reporting and withholding in 43 different states and the District of Columbia. Some of these states require personal income tax withholding by non-residents once an employee has worked in a state for a certain number of days. Maine, for example, does not require tax withholding until an employee has worked within the state for at least 13 days. Other states, however, require personal income tax withholding based on the amount of income earned within the state for a calendar year. Oklahoma, for instance, requires withholding once an employee has earned $300 on a quarterly basis. And 7 states do not collect income taxes at all. While I respect the autonomy of states to tax income within their borders, concerns have been raised by both supporters and opponents of this bill that there is widespread noncompliance with these divergent laws because it is difficult and probably impractical to effectively comply with the current system. Where employers do comply with these widely divergent standards, the cost of compliance for both businesses and employees can be staggering. I'm a co-sponsor of H.R. 1393 for precisely this reason. By establishing a uniform and fair threshold for non-resident income taxation, this legislation will meaningfully improve compliance, relieve administrative burdens, and give workers a fair deal by ensuring that the primary place of business is where they pay their state income taxes. Some opponents of this legislation have expressed concerns that establishing a uniform national standard will diminish state income taxes in certain states. But estimates by the accounting firm of Ernst & Young indicate that the bill's net impact on state tax revenue will be less than 0.01%. Accordingly, some states will receive higher revenues, while other states will lose revenue. The Congressional Budget Office agreed with this assessment in its cost estimate of a substantially similar version of the bill that passed the House by voice vote last year. For example, according to Ernst & Young, passing this bill will result in more than $3 million in additional revenue for Rhode Island, my home state. But most importantly, it will ease compliance burdens for all Rhode Islanders. And that's why the Rhode Island Society of Certified Public Accountants, along with 34 businesses with a presence in Rhode Island, including CVS Health, support this legislation. So I will ask unanimous consent to have a letter from the American Institute of CPAs dated March 16th, expressing support for the bill and indicating in it that this simplified compliance will significantly ease the regulatory burden on the employer and should enhance compliance when withholding is required. Ask that be included in the record, as well as a list
Objection, it
of
will be
the
made a part of the record.
35 states that support the legislation doing business in Rhode Island. In closing, I want to thank my colleague, Congressman Johnson, for his leadership on this bill as its lead sponsor in the 110th and 111th Congresses and the lead Democratic sponsor since the 112th Congress. And with that, I thank the chairman and yield back.
The chair thanks the gentleman, advises the committee there are 3 votes pending on the floor with approximately 6 minutes remaining in the first vote. The committee will reconvene immediately after the last vote in this series to complete this legislative measure. And the committee stands in recess.
in our last exciting installment.
The committee will reconvene. When the committee recessed, we were considering amendments to H.R. 1393. Are there any amendments? The first gentleman from New York seek recognition.
I have two amendments, but take one of them.
All right. The clerk will report a Nadler amendment.
Amendment to H.R. 1393 offered by Mr. Nadler of New York. Page 2, line 10.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. This legislation represents a major assault on the sovereignty of states and does particular damage to my home state of New York, depriving it of more than $100 million of its own tax revenue. My amendment, which I am offering along with the gentleman from New York, Mr. Jeffries, would reduce from 30 days to 14 days the threshold under this bill for when a state can tax a non-resident doing business in that state. This minor change alone would lessen the impact on New York by as much as $85 million. Simplifying and harmonizing the rules on when states may tax individuals who perform limited work in their states is a worthy goal. And I support efforts by the states and the Multi-State Tax Commission to resolve this issue. New York has been an active participant in these negotiations and wants to reach a fair solution. But imposing a solution on states, and one that would cause such a large financial burden on a particular state, is clearly not the proper answer. The power to tax is a key index of sovereignty. Yet this legislation would prohibit states from taxing activity within their own borders, except as described in the bill. I think that is constitutionally dubious. Although I take a broad view of the Commerce Clause, I do not think that it extends to a state's ability to tax a person doing business solely within its borders. This bill is also deeply troubling as a matter of policy. Under this legislation, if you work in a state in which you are not a resident for fewer than 30 days, your income will not be subject to tax by that non-resident state. But 30 days amounts to 6 weeks of 5-day work weeks. While a de minimis exception might be defensible, I hardly think that 6 weeks is de minimis. In some states, the 30-day threshold may not have a great fiscal impact. But New York State is home to New York City, the nation's center of commerce, which also sits across the river from New Jersey and just 12 miles from Connecticut. This makes New York a major destination for out-of-state business travelers and makes it by far the hardest-hit state under this bill. At this time, I ask unanimous consent to enter into the record a letter from the New York State Department of Taxation and Finance estimating that the state would lose between $95 and $120 million as a result of this bill.
Without objection, it will be made part of the record.
Thank you. This enormous financial loss would come at a time that the President and the Republicans in Congress are proposing to shift significant responsibilities to the states while simultaneously slashing federal assistance. And in a particularly outrageous move, the manager's amendment to the Trump Care, Ryan Care bill would saddle New York State with billions of dollars in additional Medicaid costs so that upstate counties can give their residents a property tax cut. If we further deprive New York of $100 million under this bill, vital services like education, law enforcement, and health care could all be on the chopping block. The results could be catastrophic. My amendment, therefore, attempts to contain at least some of this damage, to mitigate the damage. It would reduce the bill's 30-day threshold to a far more reasonable 14 days, which is still almost 3 weeks of work that someone might perform in New York without being subject to New York taxes. If employers and employees would be expected to monitor and track their time over 30 days, it does not seem like a greater imposition to do so for a somewhat shorter period, like 14 days. With my amendment, the expected impact to New York would be reduced from more than $100 million to $12 to $15 million a year. While still a significant revenue loss, this change would go a long way toward mitigating the concerns that New York has expressed. And 14 days not taxed, almost 3 weeks, should be enough for the supporters of this bill. This is a reasonable amendment made in good faith that would make the bill much fairer while still achieving the bill's underlying goals. I urge adoption of the amendment, and I yield back the balance of my time.
Chair thanks the gentleman, recognizes himself in opposition to the amendment. This amendment would lower the threshold from 30 days to 14 days before a state can tax the income of a non-resident temporarily working in a foreign state. This reduction upsets a hard-won compromise. Prior versions of the bill proposed a 60-day threshold. As a product of negotiation with the states, that trigger was reduced to 30 days, and other concessions were made. The fact of the matter is that while this amendment would benefit New York, and many people are required to go to New York for the opportunity to conduct business, it would take revenue away from the other states in which those businesses are based. Lowering the threshold to 14 days would sweep in millions of employees who would otherwise be protected and require significant renegotiation of the entire bill. Interestingly, in 2014, New York specifically rejected a proposal to increase its threshold from 1 day to 14. This only underscores the need for a uniform federal solution, and I urge my colleagues to oppose this amendment because it would upset a fair negotiated compromise. For
Mr.
purpose, the
Chair,
gentleman from Michigan seek recognition.
I rise in support of the amendment.
Gentleman is recognized for 5 minutes.
I just want to say that this is certainly not unfair. I think it's a common sense, fair amendment. I think 14 days will still provide certainty that supporters demand. To me, it's a win-win situation, so I hope my colleagues will think carefully about this Nadler amendment, and I yield to the gentleman from New York.
I thank the gentleman for yielding, and I thank the gentleman for supporting the bill. I just want to comment on what the chairman said a moment ago. The fact that an earlier version of the bill or the concept had 60 days, the fact that you had one egregious proposal and it's a little less egregious doesn't make it acceptable. The fact that this is a compromise reached by certain people, not including New York, which never agreed to it, doesn't make it fair. 14 days is more fair. It's a tremendous hit on revenue for New York and for some other states too, but New York more than anybody else, is not fair given the fact that this is revenue earned entirely within New York. So again, I urge the adoption of this amendment. I yield back.
The question occurs on the amendment offered by the gentleman from New York. All those in favor respond by saying aye.
Aye.
Those opposed, no. Any the chair, the noes have it. The amendment is not agreed to. Are there further amendments? Gentlemen,
As I said, I have two amendments. I have the second one at the
clerk
last.
will report Nadler amendment other.
Amendment to H.R. 1393 offered by Mr. Nadler of New York. Page 4, line 20, insert highly paid individual
Without
after.
objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
I thank the chairman. Mr. Chairman, this amendment, which is also co-sponsored by the gentleman from New York, Mr. Jeffries, would exempt from the bill highly paid individuals. H.R. 1393 already exempts professional athletes, certain public figures, and professional entertainers. My amendment would simply add high-earning individuals to this list of exemptions. The figure of $130,000 to define high-earning individuals that my amendment uses comes from the definition the IRS uses to determine whether someone is a key employee, in quotes, for certain purposes related to retirement benefits, and it would be indexed for inflation going forward. The rationale behind the exemptions already contained in the bill is that it is fairly easy to track what the people in those fields earned in each state. Highly paid individuals, presumably working for sophisticated operations, also ought to be expected to have the ability to track where they perform their business and how much they earned in each state. And since they are well compensated, severely limiting the ability of states to tax their business activity may have a significant budget impact on the states. In addition, as currently drafted, this legislation would provide a windfall to high-income people who often travel to other states for work. Imagine an executive who lives in a low-tax state but who travels for business several weeks a year to a higher-tax state and owes taxes to that other state. Their home state often offers a credit up to what they would pay in their home state, but they are still responsible for paying the additional higher rate in the non-resident state. Under this bill, however, if they work fewer than 6 weeks in the higher-tax state, those additional taxes would all be wiped away. This could amount to tax avoidance of millions of dollars, which is not the purpose of this bill, as I understand it. Placing a dollar limit so that people who make over $130,000, indexed for inflation going forward, would still be subject to non-resident tax would prevent abuse by upper-income people who may try to find loopholes to avoid their tax obligations. This is a simple amendment that should cause minimal disruption to businesses and individuals while limiting revenue loss to the states and ensuring that highly paid people pay their fair share. I urge my colleagues to support it, and I yield back the balance of my time.
Chair thanks the gentleman and recognizes himself in opposition to the amendment. And first, without objection, I'd like to include letters of support for H.R. 1393 in the markup materials from entities including the following: American Institute of Certified Public Accountants, American Payroll Association, Council on State Taxation, Feld Entertainment Incorporated, Mobile Workforce Coalition, World at Work, and Acuity Brands. Incorporated. And without objection, they will be made a part of the markup materials. And with regard to the amendment, I oppose the amendment because while it exempts highly paid individuals making more than $130,000 annually adjusted for inflation, a dollar threshold undercuts the bill's purpose, which is to increase simplicity for employers and employees. Many employees do not know the amount that they will earn in a year because of things like bonuses and commissions. In addition, a dual threshold with days and dollars would require two systems to be created and maintained to track employee activity. Finally, the bill already exempts certain athletes, entertainers, and public figures because they are earning money on a per-event basis, specifically from appearing at a venue in the taxing state. By contrast, for other employees, even highly paid ones, their temporary presence in a foreign state is typically incidental to their job. Accordingly, I urge my colleagues to reject this amendment, which is unnecessary and would upset a carefully negotiated compromise.
Mr. Chairman,
For purpose, the gentleman from Michigan seek recognition.
I rise to support Nadler Amendment Number 2.
Without objection, the gentleman is recognized for 5 minutes.
I support the amendment because I believe, members, that it's critical that if we are to exclude from the threshold athletes, entertainers, and highly compensated public speakers because they earn a high income, we should also exclude other high income earners, such as presidents of companies and CEOs. And so, to me, once again, fairness is involved, and this amendment would promote fairness as opposed to singling out certain individuals in the manner that they are at the present moment. Please support this amendment to get a exemption for high income earners. And I would note that I have never introduced an amendment like this in my life before now, but I think it's important. And I would yield to the gentleman from New York, Mr. Nadler.
Thank you. Again, I want to point out, I thank the gentleman for supporting the amendment and for making the observations he did. Again, I want to point out that this amendment is not to aid the high earners. It's to aid the state. And the chairman said that referenced even high earners with only an incidental contact to the state shouldn't pay taxes there. 29 days is not an incidental contact. 29 business days, 6 weeks is not an incidental contact. And again, as a general principle, we should be very careful about limiting or the ability of states to raise their own finances and certainly to tax within their own borders. So I urge the adoption of this amendment, and I yield back.
I yield back.
Question occurs on the amendment offered by the gentleman from New York. All those in favor respond by saying aye.
Aye.
Those opposed, no. In the chair, the noes have it. The amendment is not agreed to. Are there further amendments to H.R. 1393?
Mr. Chairman, I would ask unanimous consent to enter 4 letters into the record that are concerned with the Mobile Workforce Act. They're from the Marketplace Fairness Coalition, the Federation of Tax Administrators, the Multi-State Tax Commission, and a letter from 11 trade unions.
Without objection, they will be made a part of the record.
Thank you, sir.
Okay, the question is on the motion to report the bill H.R. 695 as amended favorably to the House. The clerk will call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Smith?
To hold the vote open until we have.
Mr. Shabbat? Mr. Shabbat votes aye. Mr. Issa? Mr. King? Mr. Franks? Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Poe? Mr. Poe votes yes. Mr. Chaffetz? Mr. Chaffetz votes aye. Mr. Marino? Mr. Gowdy? Mr. Gowdy votes yes. Mr. Labrador? Mr. Farenthold? Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Ratcliffe? Mr. Ratcliffe votes yes. Ms. Roby? Ms. Roby votes aye. Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. Conyers?
No.
Mr. Conyers votes no. Mr. Nadler? Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Raskin? Ms. Jayapal? Mr. Schneider? Mr. Schneider votes aye.
Since we do not yet have a reporting quorum, the vote will remain open, and members on both sides of the aisle are encouraged to get here and vote. Is that- The gentleman from Texas, Mr. Smith.
Mr. Smith votes yes. But without Bishop, maybe it's 20. Yeah. Not recorded.
Gentleman from Arizona.
Mr. Franks votes yes.
The gentlewoman from California. Yes.
Ms. Lofgren votes yes. So you have 19 total? Do we know who need 20 or 21? 21. As long as we get it back. As long as we get it back, yeah. It's like behind the, yeah. It's like in the back left corner. Okay. I don't even know what happened. Oh, here we go.
The gentleman from Pennsylvania.
Mr. Marino votes yes. Yeah. 21. We just need one more. 18 and 2, so we're at 20. Sensenbrenner, Isa.
The gentleman from Colorado.
They have it. We were right. Mr. Buck votes yes.
Has every member voted who wishes to vote? The clerk will report.
Mr. Chairman, 19 members voted aye, 2 members voted no.
The ayes have it, and the bill as amended is ordered reported favorably to the House. Members will have 2 days to submit views. The ayes have it, and the bill is ordered reported favorably to the House. Members have 2 days to submit views.
Bob, don't mention the total vote, it's embarrassing.
She already did. All right. Is there anything else?
Did you say the right bill number? What did you say, 695? Or did you say 1393?
Oh, gosh. What number is it?
1390. This is it.
Okay. All right. Golly dang. The chair would correct the report of the vote. The vote was on H.R. 1393. The ayes have it, and the bill is ordered reported favorably to the House. Members will have 2 days to submit views. This completes our business for the day. I thank all the members for being here for at least part of the time, and the committee is adjourned.
Thank you, sir.